not filling anything out right now, he's gonna go over every document on there. Everyone have a clipboard.
Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious, just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have a capital murder, first degree felony, second degree felony, third degree felony, and a state jail felony. Now, if a person was convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary or a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, you're charged with a misdemeanor. So therefore, you don't have to worry about those type of punishments. Misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, class C misdemeanors are cases that start either in the city court or the JP court, the justice court. They come to this court when a person is found guilty in one of those courts and they appeal their case. In essence, they ask for a new trial. And they get a new trial, it comes to this court, the range of punishment stays the same. Now, the range of punishment is $0 to $500. In essence, you cannot be given jail time. It's just a fine only offense. And for example, a class C misdemeanor would be not having your seatbelt on, or speeding, or having an inspection sticker that's expired. Those are class C misdemeanors. But now, the next highest misdemeanor above the class C is a class B misdemeanor. And the range of punishment for a class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail. Or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a class A misdemeanor. For the class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail. Or you could be given a fine that does not exceed $4,000. Or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. We commonly refer to unadjudicated probation as deferred probation. Now, if a person gets unadjudicated probation or deferred probation, they will not have a conviction on their record. And if they successfully complete the probation, the case will be dismissed and they may qualify for what is called a non-disclosure. I'll explain that to you. Non-disclosure means that your record will be sealed to the general public. In essence, the general public cannot have access to it. So for example, if you work in, say, at ExxonMobil, general public, they cannot have access to it because you have a non-disclosure. Now, the operative word that I used was general public. The government, police department, et cetera, and certain agencies that are listed in the Texas Code of Criminal Procedure can have access, but most of the public is general public, so they can't have access to it. Now, the next type of probation is called adjudicated probation. We had unadjudicated probation, now we have adjudicated probation. We kind of refer to it as regular probation. It does result in a conviction on your record, however, there's something that is called judicial clemency. What that means is this: it means that the judge can set your conviction aside. In essence, you will no longer have a conviction. And if you successfully now complete the probation, the judge could give you judicial clemency if three things happen. First, you have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged or let off the probation by the probation department. If those three things happen, then the judge can set your conviction aside and you will no longer have a conviction on your record for that offense. Now, however, if you get another conviction later on, we call that a subsequent conviction. If you get another conviction later on, then the court, then what can happen is the case that you received judicial clemency on can be resurrected. It can be brought back up, revived, and used against you. And if you try to get a license with CPS, Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, the paperwork that you have on the clipboard, I'm getting ready to go over that paperwork with you. Now, the first document I need everyone to look at is behind that small sheet. It's titled Judge's Explanation of Rights to Defendants Without Attorney. And that document should look like this. Okay, that should be the first page, okay? Now, we're gonna keep going back to this document because before we leave, everyone here, for a case, will have to read, initial, and sign this document. You're gonna initial on one of the 5 lines, we'll get there. Okay. Now, this document states the first sentence: as a defendant in a criminal case, you have 3 options. That is 3 options regarding your right to have an attorney. And it says, number 1, you may hire an attorney. Number 2, if you can't afford to hire an attorney, you may request that an attorney be appointed to represent you. Now, number 3, you may represent yourself. Now, the first paragraph below number 3 states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire an attorney. The second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. So you can ask the court to appoint an attorney to represent you. But you must first fill out the financial questionnaire so that we can determine whether or not you qualify for a court-appointed attorney. Now, this is only for people who want to apply for a court-appointed attorney. If you are wanting to hire an attorney, you don't have to worry about that. Let me get ready to say. If you want to apply for a court-appointed attorney, then you have to fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is on the clipboard and is titled Affidavit of Issues on Jackson County Affidavit. It should be the second document. It's a 3-page document. Now, this is for people who would like to apply for a court-appointed attorney. You will have to fill out this first page. Okay? You would have to fill out the first page. Once you fill out the first page, you go to the second page. And on the second page, the only thing that you would have to do is fill out the top portion that is titled Defendant's Oath at the top. Defendant's Oath, you'll fill that little section out. And then you'll go to the middle section where it says unsworn declaration by defendant. You'll fill that out and then you'll stop. Okay? Now, the next paragraph is for people who would like to represent themselves. All right? We're going back to the first document. The next paragraph states that, now, let me explain this to you. If you would like to represent yourself, that means that you will be your own attorney. You will not have an attorney represent you, you'll be your own attorney. And because you will be your own attorney, you will be able to talk to one of the assistant criminal district attorneys. We call them prosecutors. We have 2 of them here at court. And if you would like to work out a settlement on your case, we call that a plea bargain. Okay? If you want to work out a settlement, you'll be able to talk to them. Okay? This paragraph states, the third paragraph states that you may not speak to the prosecutor unless you first sign a waiver of your right to have an attorney. Now, the waiver, this is only for people who will be representing themselves. The waiver is a 1-page document on the clipboard. It should be behind an affidavit that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. This is only for people who will be representing themselves. So if you are hiring an attorney, you don't have to worry about this. If you are applying for a court-appointed attorney, you don't have to worry about this document. Only people who will be desiring to represent themselves would have to read and sign this document. Okay? Now, going back to this first document, the next paragraph, the one that's in block form, this is for people who will be representing themselves. It says that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, this last 1-sentence paragraph states that you may change your mind at any time and request that an attorney be appointed to represent you. So I'm giving you an example. So let's say you decided to represent yourself. And then let's say you talk to the prosecutor, see if you can work out a plea bargain agreement. Let's say you want to see if the prosecutor will be willing to give you deferred probation. But the prosecutor says, no, we want to give you jail time. And so you say, well, I don't want the jail time. I don't want that off. You can say, well, judge, I want to apply for a court-appointed attorney. And that's because you can change your mind, is what I'm saying. Okay? All right. Now, at the bottom of this sheet, in bold letters, it states defendant's choice. Mark initials next to only one choice. So everybody is going to make a choice. One of these 5 choices. Okay. If you would like to hire your own attorney, you will place your initials on the first line to the left, sign it at the bottom where it says defendant, dated, and stop. And the day's date is October 21st, 2025. Okay, and this is the only document you have to sign. All right? So if you want to hire your own attorney, you initial, dated, initial on the first line, sign and date it, and then it's the only document you have to worry about. If you've already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Okay? Then you'll sign and date it, and then you'll stop. This is the only document you would have to sign. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left, the third line at the bottom. Place your initials there, and then you will sign what it says defendant. You will date it with today's date, October 21st, 2025, and then you will fill out the document, the first page of the document that is titled affidavit of indigence. And then you'll go to the second page, you'll fill out the top part that says defendant's oath, and then the middle portion that is titled unsworn declaration by defendant, and then you'll stop. Okay. Now going back to this page, if you've already been appointed a court-appointed attorney, then you'll put your initials on the fourth line to the left. Then you'll sign and date it and stop. Now, if you would like to waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line. Okay, on the fifth line, sign, date, and then you would have to read and sign the document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And then you'll stop. Okay, do we have any questions? Any questions before we go on? All right, now we're gonna give you time to fill out the paperwork. I need to go over some more rights that you have. And one right that you have is your right. Well, before I get to your right, let me tell you about the three types of pleas. A person can enter a plea of not guilty. If they enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. We call it no contendere, which means you will not be fighting or you will not be contesting the charges. All right. Now, you have a right to have a trial by jury. For those young people that are sitting in that area, we call that the jury box. Okay? 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's presented by the state and the defense. They will listen to the arguments of the state and the defense, and then they will go back into the jury room to deliberate to decide whether to find you not guilty or guilty. You also have a right to waive your right to have a jury trial. Waiving your right to have a jury trial means that you're giving up your right to have a jury trial. Now, if you waive your right or give up your right to have a jury trial, you still can have a trial, but it'll be a trial without a jury. We call that a bench trial, where it'll be a trial by the judge. The judge sits on the bench, they call it a bench trial. So you'll have a bench trial, the judge will be the judge and the jury in the case. The judge will listen to the evidence that's being presented by the state and the defense. The judge will listen to the arguments of the state and the defense, and then the judge will apply the facts of the law and decide to find you not guilty or guilty. Now, you also have a right to not go to trial. You might want to enter a plea of guilty, no contest, and see if you can work out a plea bargain with the state. And if that's the case, then there are two types of plea bargains. One type is called an agreed plea bargain, which means that you and the state has reached an agreement. And the other type of plea bargain is called an unagreed plea bargain, which means that you want the court to decide what your punishment is because you could not reach an agreement with the state. So if you have an agreed plea bargain agreement, then that case comes before the judge, and the judge could do one or two things. The judge can either accept your agreement or reject your agreement. Now, if the judge, if you, let's say you worked out a plea bargain, you wanted deferred probation, and the district attorney offered you deferred probation. So that's the agreement, it comes before the court, and the judge said, I'm not gonna follow that plea bargain agreement, then if that happens, well, you can tell the judge, since you're not following that plea bargain agreement, I take my plea back. In essence, I'm not pleading guilty, I'm not pleading no contest, you have a right to withdraw, which means to take back your plea bargain agreement if the judge does not follow the agreement. All right, now, if the judge does follow the agreement, let's say the judge followed the agreement, and let's say within 30 days of the disposition of your case, of the 30 days of you selling the case, you decide, you know what? I think I've been wrongfully convicted. I think the court committed an error by convicting me. I want to appeal my case. Well, if that happens, you have to get permission from the judge that followed the plea bargain agreement. Get permission to appeal your case. Now, if the judge gives you permission, what's going to happen with your case? Well, the case is going to leave this court and it's going to go to the Ninth Court of Appeals, which is right upstairs. There are 4 judges up there. They will review your case to see, one, whether or not you've been wrongfully convicted or whether or not the court committed an error by convicting you. And they can do one of 2 things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court with orders, order this court to give you a whole new trial. Now, if they deny your appeal, no problem. Because you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals. They're located in Austin, Texas. Now, you have to file what is called a pro se petition for discretionary review. I will explain that to you. It simply means, pro se means I'm by myself, I don't have a lawyer, I'm pro se. And I'm petitioning or asking the court in Austin to review my case, to see whether the Ninth Court of Appeals should have granted my appeal, or whether this court committed an error, or whether or not to see whether or not you were wrongfully convicted. They can do one of 2 things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty and the case is over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your petition at that point, then your conviction will stand. All right. Now, the next right that you have is, I talked about an agreed plea bargain, or unagreed plea bargain. You and the state have talked. They want to offer you jail time, you want deferred probation, you say, well, I want the judge to decide. So the judge will decide what your punishment will be within the punishment range of the case. Okay? That's all. That's what an unagreed plea bargain means, that the judge will decide the punishment. All right. Now, you also have a right to have witnesses that come to court. Okay? Let's say you want to go to trial, you have a right to call witnesses. They sit in a chair with the microphone, we call that the witness stand. Now, witnesses, they can either testify for you or against you. Now, if you represent yourself, you can ask a question. If you have a lawyer, your lawyer can ask a question. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses, meaning that you have a right not to call any witness. Now, if you waive or give up your right to call witnesses, that does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have what we call a Fifth Amendment right against self-incrimination. What that means is this: you have a right, according to the Fifth Amendment of the United States Constitution, not to testify against yourself. Okay? So the state, the government, DA's office can't force you to take the witness stand. If you invoke your Fifth Amendment right against self-incrimination, you have a right not to testify. Now, that makes sense Because the reason why it makes sense is because the state has the burden to prove you guilty. They have to prove you guilty, right? You don't have to prove yourself guilty, right? So that's why you have a Fifth Amendment right to remain silent. I know a lot of times we watch television, we see Law and Order, we see the television lawyer, you go up to the witness stand and ask the witness a question. Witness, I take the fifth. Boom. They can't do that. Okay? They exercising their Fifth Amendment right against self-incrimination. Okay? And so that's what, you know, she's here on the head. You can send it back. Yeah. Okay. So you can exercise your Fifth Amendment right against self-incrimination. All right. Next, you have a right to have what is called discovery. Discovery means that you have a right to see or discover what's in the state's file. You have a right to see evidence that the state will be using against you. That's what it's called. Yes.
That'd be like police force.
I was going to explain to you. Discovery, you have a right to see your statement, witness statements, police reports, lab reports. You have a right to see video recordings, photos, listen to audio recordings, documents, instruments. You have a right to have access to it so that you can prepare for trial. Your attorney will, if you're represented by an attorney, your attorney will have access. If you represent yourself, you would have access. Okay? We call that discovery. I guess it's because you have a right to discover or see what's in the file. All right. And so you can waive your right to discovery as well. If you waive or give up your right to have discovery, what that basically means is that you will not be having access. You don't want to see the evidence. Okay. You have a right to waive. Okay. Just like any right that you have, your right to waive it if you desire to. Okay. Now, everyone that's here for a case, you've been charged with an offense, you've been arrested, placed in Jefferson County Jail, or placed into a jail. It could have been out of county. You bonded out, you're out of jail on either a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you pay a bondsman a percentage of the bond to get out of jail. Or you are out of jail on a personal recognizance bond or a PR bond, which means that you did not have to pay any money to get out of jail. You were just simply released under your own personal recognizance with a promise to appear here in court. Okay. I said that to say this. Every day that you spent in jail, it can be used as credit toward your punishment. The opposite word is every day. So let's say you were booked in jail last night at 11:59 p.m. And then you booked out of jail 2 minutes later at 12:01 a.m. That's 2 days. Why? Because it's 2 different days. It's not 24 hours. It's 2 different days. Like Monday and Tuesday, 2 different days. Okay? Except that, separated by 2 minutes in my scenario, but it's 2 different days. So you get credit for 2 days. So let's say you spent 5 days in jail. And let's say you talk to the prosecutors, they offer you 5 days in jail. That simply means you won't have to serve any more time in jail. Why? Because you'll be given credit for the time that you've already served. So therefore, you won't have to spend no more time in jail. Now, if the state is offering 7 days in jail and you spend 5 days in jail, you will only have to spend 2 days in jail. Why? Because you already have 5 credits. So you will take 5 from the 7, at least 2. Now, every day that you spent in jail also can be used as credit towards your punishment. Every day that you spent in jail, you get $100 credited toward your punishment. So, for example, in our scenario, you spent 5 days in jail, that's $500. State is offering you fine and court costs of $500. That means you won't have to pay anything. Why? Because you've already spent 5 days in jail, you have $500 credit. it will be taxed every time. Now, if the state is offering fine and court costs of $700, you have $500 credit. That means we'll take the 500 from the 700, and that leaves 200. And you'll be required to pay the $200 on the day that the case is disposed of. Now, if you cannot pay, no problem. Because we can put you on a payment plan until it's paid off. You can pay in small monthly installments until it's paid off. Now, maybe you may not be able to pay it off even if we put you on a payment plan. No problem. Because we can convert the fine and court costs to community service. And for every 1 hour of community service that you perform, you will receive $12.50 toward your fine and court costs. So in our scenario, if you owe $200, okay, $12.50 times 8 hours is $100. All right. So if you work 8 hours one day, that's $100. You work and if you work 2 days, 8 hours, that's $200. So that means you will be paid up. Okay, so if you do your community service 2 days, 2 8-hour days, you finish. All right. And so those are the things that the code, so let's say the code of Texas Code of Criminal Procedure, allows individuals to do to pay off their fine and court costs. Now, Jefferson County has a program for people who have not been charged with criminal offenses before. This is your first time getting in trouble, charged with criminal offense. Jefferson County has a program where they will dismiss your case. And they will wipe it off your record. Okay, let me explain the program. The program is called pretrial diversion. With pretrial diversion, in order to qualify, 3 things has to happen. 1, it has to be your first time getting in trouble with the law. You know, having cases filed against you. 2, it cannot be an offense for unlawful carry of weapon or resisting arrest. And 3, you have to have an attorney to assist you with the application process. The attorney could be a court-appointed attorney. It doesn't have to be somebody you hire. Okay. They just have to have an attorney to assist you with the application process. Okay. If you get into the program, they will dismiss the case. You complete the program, then you can get it expunged from your record. Expunged means erased, deleted, or wiped off of your criminal record. It's gone, like it never happened. All right? We call that pretrial diversion. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. That program is for veterans only. It doesn't matter what branch of the military you're in. And with that program, once you get into the program and complete the program, they will dismiss the case and you may qualify for what is called a non-disclosure, where your record will be sealed to the general. All right. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking off. The program is called the Community Safety Initiative, CSI. It's the CSI program. And with that program, the program is simply designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so how do we stop it? Well, we have the Community Safety Initiative. And with that program, we have partnerships with various agencies in our Golden Triangle area, okay, Southeast Texas. And one of the agencies that we have a partnership with is Spindletop. We have some folks with Spindletop. They'll come to you in a few minutes and tell you a little bit more about the program. We have this partnership with Texas Care. We have some individuals who are going to come and tell you a little bit more about that program. And we also have a partnership with Family Services, who has a program that is called BIP, Battles Intervention and Prevention Program. That's for individuals who have assault, family violence type cases, and they have programs as well. Now, with Spindletop, what they will do, they can do an interview, a private interview, either in our jury room, at their facilities, by telephone, whichever is convenient for you. Then they can do what is called an assessment to determine what your mental health issue may be. And then they can do a treatment plan, either outpatient or inpatient treatment to address your mental health issue. Now, you do not have to be incompetent or insane to participate in the program. You could merely suffer from anxiety or depression or any other host of mental illnesses. They have the expertise to address those issues. We also have a part, now Spindletop has a program that is called ATAR. ATAR is just an acronym, ATAR, that stands for Addiction, Treatment, and Recovery. It is a drug treatment and recovery program. Drug and alcohol treatment and recovery program. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR. OSAR, an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do, they can do a screening, an assessment to determine what the issue may be with drugs, alcohol, drugs and alcohol. And they can do a treatment, they can develop a treatment plan for either outpatient or inpatient to address your drug and alcohol issues. If you're unemployed, maybe you're looking for a better job. Well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center, Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, they will assist you in getting a job in the area that you're trained in. If you have not graduated from high school or you do not have a GED, well, they also have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. Therefore, I like to say that when you come to county court at law number 2, Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we have brochures for people that you can talk to get into these programs so that you could be on the road to living your best life. Okay? So, as I mentioned to you earlier, we have some folks here from Spindletop. They're going to come and talk to you a little bit more about the program that Spindletop has to offer. We have Caitlin and Tanya.
Thank you, Judge.
You're welcome.
Hi, my name is Caitlin and this is Tanya. We're qualified mental health professionals from Spindletop, and normally you will see us with a mental health deputy, and he had to leave today. What we do is normally we ride around with our mental health deputies in the community, and we respond to calls and we offer our assistance if somebody has anything mental health going on. So they have some type of support or somebody there to make them feel comfortable, so it's not just them and the officers. So what we have on your clipboard is a small little piece of paper. This is not a court document, it is a spinal document. Whatever you write on that paper is between me and you. I don't tell the judge, I don't tell nobody else in court, and this is also optional. You do not have to fill the paper out, and if you don't fill it out, you can leave it blank on your clipboard, so you can always reuse the paper. What the paper is for is to get you resources. If you were to check mental health, which can be depression, anxiety, or PTSD, or substance use, which can be any type of drug or alcohol, we can get you into spinal tap services or any services in the area to help you with that resource. That includes talking to somebody like a counselor or a therapist, talking to a doctor to get medications for mental health. Yes, sir.
You already have factors that you're looking to.
Huh?
You already have just your system.
Yeah, if you already have one, you can stay with who you have, and then Center Hub offers other services. We also have support groups and support classes, and anything outside of that, we can help you find as well. If there's something that I said that we offered, and you want something different, we can help you find it in a different facility in any area that you choose. Our job is to offer assistance. If we don't have what you're looking for, we can help you find something else. If you would like to talk to us today in person about Spindle Top or helping you look for a resource, please write on your paper, please talk to me today. And when the judge through review, I'll come and get you and we'll put you to a back door and we can talk privately. If you just want me to call you, you can check call and me or a coworker will get to you within the week. And somebody have any questions? Okay. Yeah. Okay, so thank you guys for your
Okay.
time.
Thank you, Tanya and Caitlin. Okay, at this time, we have Ms. Smith with Texas Care. She's gonna come forward and tell you a little bit more about the program that Texas Care has on.
Hello, I'm Juana Smith. I work for Texas Care Center. I've been doing this for a very long time. I have a master's in addiction and I'm also a qualified mental health professional. I'm the lead supervisor with Texas Care. I answer the phone 24/7. If you call my number, we can see if you qualify for services. We do accept Medicaid and we do work with children as well. So if you've got kids, we can work with them. We do life skills. We do emotional and behavioral support. We help you with referrals and resources. Some of the other things that we do, we come out to your home. We don't expect you to come to the office. We come wherever you are to get your kids signed up as well. We come out to the homes, to the schools, to the daycares. Currently, we work closely with Child Protective Services as well. Megan, come up here with me as well. This is one of our coworkers as well. So I have two qualified mental health professionals here with me today. I have Claudia and I have Megan who just walked in. We go out in the field, we work one-on-one with you. And we help you with any kind of resources that you need. We have almost all of Region 5, we have offices set up. So we have workers that come out. And most of my QMHPs do answer the phone 24 hours a day, 7 days a week if you're on their case. And so we can help with a lot of things. We help you find a psychiatrist. We help you find any kind of programs that you're in need of. So if you're interested in services, get with us and we can get you set up.
Okay, thank you, Ms. Smith. At this time, we'll have Johnny Stewart. He's with Family Services. He'll tell you more about the program and Family Services has to offer.
Thank you, Judge.
Okay, you welcome.
Good morning. I'm Johnny Stewart. I'm the Batterers Intervention and Prevention Director. It used to be called the Domestic Violence Program. If you have your first charge for family violence or domestic violence, we offer this as part of the pre-trial diversion program for our big program. It's 18 weeks with Family Services. It's a 2-hour program. We have Zoom along with in-person, and we have women's groups and men's groups. But this program is to try to help you change those behaviors to keep people from coming back to the sport. One thing that I like what the judge said is, address the problem, that's the problem. We're addressing those behaviors and those behavior changes. So this program has been going on for a bit. Family Services. We also have a women's and children's shelter, and we get ready to open our brand new shelter at the end of this month. And we also have other services. Ms. Tina is our non-residential director, and that's for the victims who are being need services. So please take advantage of these services that the ADAs are offering. And we hope to change some of those behaviors to keep you from coming back to school. Thank you very much.
Okay,
Judge,
thank you.
Appreciate it.
Stewart.
Mm.
Okay, now, ladies and gentlemen, the paperwork that you have, I'm gonna give you time to fill that paperwork out. If you need help with filling the paperwork out, we have our 4 personnel, including myself, who will be happy to help you with filling the paperwork out. We're going to pick that paperwork up from you, and once we pick the paperwork up and go through it, we're gonna call you up before the bench, one at a time. Now, we're gonna put you into 1 of 3 categories. One, if you want to hire an attorney, then, your case will be reset today so that you'll be given time to hire an attorney. Now, if you would like to apply for a court-appointed attorney, if you qualify for a court-appointed attorney, that attorney will be appointed before you leave here. And 3, if you would like to waive your right to an attorney and represent yourself, and if you talk to the prosecutors and you are able to work out a plea bargaining agreement that's acceptable to you, then the case will be disposed of today. Okay, now, it's gonna take us a little time to pick up the paperwork, so if you need to use the restroom, there are 2 restrooms that are right outside. We have the men's restroom in front of County Court at 11-3, which is right next door. And on the opposite side of the hall, we have the women's restroom, which is in front of the 172nd District Court. Now, you'll be allowed to use the courtroom, use the restroom. And so when you use the restroom, please come back into the courtroom. Do not leave the courthouse before your case is called. Because if you leave the courthouse, and your case is called, you're not here, well, your body's gonna be forfeited. A warrant gonna be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail, and guess what? We'll have to go through this all over again. And so, in order to save us some time, just conduct yourself, be mindful that we're still in court, conduct yourself accordingly. And we'll try to get you in and out of here as fast as possible. Okay? So at this time, the court will be in recess. As I mentioned to you earlier, if you need any help, just simply raise your hand, and someone from the court personnel, including myself, will be happy to assist you. Okay, the court will be in recess, and we'll be getting started in 3 minutes. Oh, just one.
Please finish your paperwork, before you step outside. If not, you're gonna prolong your name getting called.
Okay, ladies and gentlemen, I'm getting ready to get back. The court is back in session. With the arraignment docket, first case is cause number 25 CCCR 2076, case is filed in the state of Texas versus Brandon Smith. Smith, would you please come forward, stand before the bench? Mr. Smith, your full name is Brandon Smith?
Yes, sir.
Smith, would you need to take that gum out your mouth and put it in the trash can to your right? Okay, Mr. Smith, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. How are you doing, Mr. Smith?
Now, I could be better, but
Okay. Now, Mr. Smith, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Mm.
And are these your initials on the line that states you'd like to apply for court-appointed attorney? It's Osby.
Yes, sir.
I was looking at his affidavit. It's not filled out. I looked to see that he's working. I thought I was assuming that he wasn't. So he needs to finish. He needs to complete that. Just have give him a clipboard and a pen. You could have a seat back over there. Next case is cause number 25 CCCR 1914, case is style of state of Texas versus Carson Smith. I mean, it's Carson Moore. Carson Moore. She must still be in the felony court. Okay. Next one. Next case is, let's see. Cause number 25 CCCR 2080, case of style of state of Texas versus Charlene Monk. Ms. Monk, your full name is Charlene Monk?
Charlene Moak.
Charlene
Moak.
Moak.
Yes, sir.
Okay. Okay, Ms. Moak, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Moak, you may put your hand down. How are you doing, Ms. Moak?
Mhm.
That's good. Now, Ms. Moak, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Ms. Moak, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Moak, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Oh, you know what? I need to give her some bond conditions, I think. Hold on. Yeah, have her come back up. I need to give her some bond conditions.
Yeah.
Okay, I'm still filling it out. Okay. Here you go. Here you go. Hey, Ms. Mo, I need to give you some bond conditions. The court, bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. You see that document? I'm going to go over this document with you, and it states that standard bond conditions in County Court at Law Number 2, and it states following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition?
Yes, sir.
And condition number 4 does not apply. That only applies in a DWI case. And however, condition number 5 does apply, and it states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, this smoke, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant can be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail. Please have a seat in that first chair and wait for your name to be called. DeQuinton Smith. Okay, Mr. Smith, your full name is DeQuinton Keon Smith. Okay, Mr. Smith, would you please raise your right hand? Mr. Smith, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Smith, you may put your hand down. How are you doing, Mr. Smith? That's good. Now, Mr. Smith, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials on the line states you'd like to apply for a court appointed attorney? I also have another document. Miss Bailey. He was putting that, he was at least to put some zeros. Let's see, we get told about. Just gave him a pen. She's gonna give you a pen. Yeah. DeQuinton Smith, yeah. Okay, now, Mr. Smith, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line as titled defendant? Or these your initials on the line that state you like to apply for court appointed attorney?
Sir.
I also have another document that is titled, we'll put this in, that's titled Affidavit of Indigence. You recognize this document?
Sir,
On page 2 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
sir,
Mr. Smith, before you sign and initial these documents, did you read the documents?
yes,
Did you understand what you read?
sir,
And is everything in these documents true and correct to the best of your knowledge?
yes, sir,
Mr. Smith, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Here you go. L.C. Berry. Mr. Berry, your full name is L.C. Berry.
yeah,
Hey, Mr. Berry, would you please raise your right hand? Mr. Berry, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
yeah,
Mr. Berry, you may put your hand down. How are you doing, Mr. Berry?
good,
You doing good? That's good. Now, Mr. Berry, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants by Attorney. You recognize this document?
yeah,
Is this your signature on the line that's titled Defendant?
yeah,
Are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature on the line that's titled Defendant. Is this your signature?
yes,
Now, Mr. Barrett, before you sign and initial these documents, did you read the documents? You understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Barrett, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Lori Perazzo. Attorney Perazzo will be given information to contact you. And you will also be given information to contact her. Our court coordinator will give you that information. Now, before she gives you that information, I need to give you some bond conditions. Okay, Mr. Barry, Bailey just handed you a document that's titled Standard Bond Conditions and County Court Law Number 2. I'm going to go over these bond conditions with you. And it states, following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. You understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yeah.
Now, condition number 3 and 4 does not apply. Condition number 5 does apply, and condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a political subdivision or state agency. Do you understand that condition?
Yeah.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yeah.
Okay, just have a seat in that first chair on the wall. Next case is Trevor Stratton.
Thank you, Your Honor.
All right. Mr. Stratton, your full name is Trevor Joseph Stratton.
Yes, sir.
Stratton, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Stratton, you may put your hand down. How are you doing, Mr. Stratton?
Pretty great.
That's good. Now, Mr. Stratton, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line stating that you like to apply for court-appointed attorney? I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Now, Mr. Stratton, before you sign and initial these documents, did you read the documents?
Can you explain the last thing, and then that's just saying I want a court appointed?
Yeah, on these documents, you said you want to apply for a court-appointed attorney.
Yes, sir.
Okay, now, did you understand the documents that you signed?
Yes, sir.
Okay, and is everything in these documents true and correct
Yes,
to the best of your knowledge? Okay, Mr. Stratton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. But before she gives you that information, the bailiff is going to give you a document that is titled Standard Bond Conditions and County Court at Law Number 2. And I'm going to go over this document with you. This document states that following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
I'm quite clear about that. If we live in the same household,
Okay.
how does that work out?
Well, state, I need a prosecutor up here.
Because my dad counted, he's never counted in the day. I'm trying to figure out how that works. I don't want him to leave me.
That door is locked, sir. You gotta go through the other door.
Said you might, I don't want him to.
Hold on a minute. Yeah, the second bond, the third bond condition is stated the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. And the defendant shall not go near any residence, school, or other location frequented about the alleged victim. And this is an assault, bodily injury, or family member.
Yes, Your Honor.
So he's saying that,
That's my only way to get the word too.
well,
Yeah, I agree.
well, I mean, are you saying that they live together or something like that? I think what you might have, well, let me look at the facts of this. Hold on a minute. What's that? Stratton. Affidavit. Oh. Okay. There you go. Minute.
Also, you know.
Hold on a minute. Well, yeah, State, you had opportunity to read the, PC and the, in this case,
Yes, Your Honor.
okay. I don't think I'm not gonna remove that condition. Miss, Mosley? Yeah. Now, Mr. Stratton, somebody's gonna have to find somewhere else to stay. Okay? So that condition is, that statement of the condition is not gonna be removed based on probable cause affidavit and that's in this case. I don't think it'd be wise for that condition 3 to be removed. Okay?
I mean, it's just-
You can talk to your attorney about it.
No, I'm saying like, what am I supposed to do?
I don't know. Well, you violate these bond conditions, your bond gonna be revoked. You'll be arrested and you'll be placed in Jefferson County Jail. Okay?
But if I don't, then I'm just gonna be homeless and jobless.
Well, the thing I gotta say, you can talk to your attorney about that. I mean, I'm looking at the PC and there's some disturbing facts in this probable cause affidavit.
Other question I have for Your Honor,
Mhm.
it says, drugs and, said your medication as well,
What are you talking
where it
about?
says drugs or something in here.
Oh, no, that's basically saying that the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Now, no doctor is gonna prescribe alcohol.
No, I'm saying I'm
Okay.
prescription medication.
Okay, they'll know the difference between prescription medication and illegal medication.
I know this, all I'm asking is, I'm not gonna get in trouble.
This is illegal, we're talking about illegal medication. Okay? Okay, so, I mean, if somebody's testing a Tylenol or something come up, you're not gonna get put in jail for that, right? So, we talking about illegal drugs.
I just not think I think my sleep medicine is a controlled substance as well.
Okay, well, but you'll be able to provide all of that information to your attorney. And your attorney know what to do. Okay? Now, but this, condition number 3, you shall not communicate either directly or indirectly with the alleged victim of the pending offense. And the defendant shall not go to any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
But if you try to communicate or follow me around.
You can talk to your attorney about that. Okay? I'm not here to give you any legal advice. That's why you have an attorney. I can't give you any legal advice because I'm not your attorney. Okay? As a judge, we're prohibited from giving legal advice. Okay? Now, condition number 4 does not apply. That only applies in the DWI case. However, condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay. Now, in condition number 7, states that defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Okay, so you need to have an ankle monitor within 3 days, and you can provide proof to the court. Will she have the information of the places that you can go to get it? Okay. Now, if you violate any one of these conditions, your bond gonna be revoked. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
What's that, ankle monitor doing?
What is it for? Make sure we can keep track of you. You threatened that you said the next time you will fight, you will kill him. According to the PC affidavit, okay? So we need to keep track of you.
The PC
That's the probable cause affidavit, police report.
That my.
That you, no, that you made to the statement that you made to the police officer.
Enforced.
Right. Okay. Just have a seat in that first chair and wait for your name to be called. Right?
Not hard.
Okay. So you stated here that you're gonna be working 60 hours a week,
Mm-hmm. That is almost.
60 hours a week.
Yes, sir.
Okay. Well, let me do this here. How much do you make an hour? Simple. You don't qualify for a code appointment.
All that information is from my last job, like she just said, you know.
I didn't, the information I'm using is from your current job. 60 hours a week,
Yeah, but I.
25 hours.
I start tomorrow, that's what I'm saying. Like, I'm already out on the bond, man. I come to court
Okay.
today.
Okay, let's stop right there. You said you're out on bond. You said first before that, you said man.
Excuse me.
Okay.
No offense. I'm out on court for this.
I know, I understand.
Right now.
Understand?
Then I get here this morning.
You got a new felony case that they indicted you on.
No, it ain't nothing new. It's something old. And
Okay.
I don't even understand because I'm already on probation for a felony case. And when I got out of
Oh,
jail,
I don't know.
that shit,
It could, is it a motion to revoke probation?
No, it ain't no motion.
No, I'm asking her.
The habeas.
That's what I'm trying to understand.
Oh,
I don't even understand what's going on. You know what
But
I'm
we,
saying? 'Cause when I went
hold on a minute. Could you look up, the case to see what he has a warrant on? We'll find out what it is. And that's not out of this court. That's out of, one of the courts down the hall. the felony court.
Yeah, but all I'm saying, all I'm trying to get you to understand is, I went to jail last year, and I stayed in jail 52 days for, I went to jail for resisting arrest. What
Okay.
I'm in court for right now.
Okay,
When I went to, when I went to court,
hold on. You was in jail 52 days on a misdemeanor?
52 days last year.
They must,
This
you must have
case,
been in jail on something else too.
You know what I'm saying?
Cause on a misdemeanor, we see people on a weekly basis.
I'm trying to explain to you, you know, shit.
Okay,
So I already had, you know what I'm saying, 2 possession cases, right?
were they felonies or misdemeanors?
Felons.
That's why you were in 52 days.
So when I went to court, they threw one of them out. And,
Okay.
And they put me on, I got a plea deal, they put me on probation
I understand.
for the other. So I've been out of jail since September 4th of last year on probation.
Hold
Right.
on. She just found some information out on your, on the case that they just filed. What is it?
They filed it September 17th, of possession.
They just filed a new possession case.
But this nothing new.
Your Honor, likely we were waiting on lab results. It is a possession case.
Oh, it's the same possession case that was filed before?
Saying that's likely. what-
That's probably what
We're looking at
happened.
Right now, because I mean, we have to wait for lab results to get in, and then at that point, they would be
I mean,
indicted.
No,
what's the date?
let me, okay, you talking about the date of the offense?
Yeah.
Okay.
The same as the felony, Your Honor.
Oh, it's the same as the one that he's on probation for. That's,
The probation, the one that I have is active. There's an active felony possession, and it's the exact same criminal episode as this misdemeanor he has this court here.
Man, it ain't no way.
okay. Well, no, we're not saying, you know,
That's bull.
that's just an allegation. That's what they filed. Okay, that's what they filed. What she was saying, listen.
That's why I did.
Okay, listen to what you just said. Just what you said. You didn't go.
Over a year later, they coming with this, man, like this crazy, man. This don't even make sense.
I know, but let me tell you this here. There's something they call they have statute of limitations, which means that they have so many years. For example, on a misdemeanor, average misdemeanor can be filed within 2 years of the date of the offense on a misdemeanor. Some felonies could be filed later than that. So basically, even if that occurred a year ago, or they still can file it because it's within the statute of limitations, is what I'm saying. Okay, so what she said was that the reason why it wasn't filed earlier is because they had to send the drugs to a lab.
It don't take that long to, you know.
Apparently it took that long for these results. Is that correct?
That could take a while.
Yeah.
Man, it don't take that long to get no lab.
Okay.
Stop.
I'm just saying, that's just what they're saying. But anyway, you have this felony case filed again.
And then when I went to jail, I wasn't even initially charged with no.
I understand.
I'm saying, like, where all this coming from, man? This
I
doesn't
don't,
make sense to me.
but just, that's not in this court. You're gonna have to talk to the judge in the court in which the case was filed in.
Then I ain't even get nothing in the mail saying that I even had a woman. I'm already out on bond.
Okay, but you're not
I'm
on,
on probation.
okay.
You know what I'm saying? Like, why I wasn't even informed of none of this going on. You know what I'm saying? I get to court this morning, all of a sudden they you know what I'm saying? Then over a year later, they talking about, then she talking about some lab. It don't take that long for no lab results, man.
Okay.
Well, let's be honest, man.
Okay, now
They
you,
use
hold
common sense, man.
on.
That don't take that long.
Hold on. Let me do this here. I told you the first time you said man. Don't do that. You said man 2 more times after that. Hold on. Oh, no, okay. I understand. But listen, just settle down. Just settle down and relax. Take a deep breath. You know, only thing I'm saying now, there's nothing I can do about that. Like I told you, that case was not filed in this court. It's a felony case. We only handle misdemeanors here. We were only trying to provide you with the information, the limited information that we have. Okay, but there is a warrant that comes out of another court for that particular offense. You're gonna have to deal with that in that
Can
court.
I ask you something? I want
No,
to
no, hold on. No. Mention, no. Only thing she did, she's a misdemeanor prosecutor in this court. She is not the felony, she is not the prosecutor.
what you
Who's,
do.
no, but she's not handling that court. We only did this as a courtesy to you. She's not handling your case. You're gonna have a defense attorney who's gonna handle your felony case. There'll be a felony prosecutor in that case. They can talk, y'all can talk and see if they can come to some type of resolution to this case or to that case. But let me get back to where I was. I was talking about your affidavit of indigence. And based on your affidavit of indigence, I don't think you qualify.
Man, I'm finna go to jail now, so how I don't qualify?
Okay. Well, we'll bring you back. But you're saying that this is what you're making now. Okay. So you don't qualify now. Next week you might qualify. Okay,
Yeah.
I understand.
Jesus, yo.
Okay, so just just settle down. You have I think your mom was here earlier. Okay. And they may be making some arrangements as we speak. I don't know. But just settle down and everything things that have a tendency to work out. Just be patient. We can't do any all of the things that you're worrying about right now, we can't solve that problem right now. Because as I mentioned to you earlier, the case is in the felony court, it's not in this court. Okay, so I don't have I don't have no jurisdiction over that. All right. So what we're going to do at this time, you don't qualify for a court-appointed attorney based on the income that
I don't even be doing that, man. You know what I'm saying? Like I be all out the way and everything, man.
okay.
Man,
Just kind of settle down right now. Okay. So what we can do, Miss Mosby, now since you don't qualify right now, the only other two options that you have, you can have your case reset to hire an attorney, or you can waive your right to attorney and represent yourself. So those are the options, and that's what's already listed here. Okay. Okay. Just he can have a seat back up there. He doesn't he just have a seat right there so he can make his decision. You don't have to just rush through it right now. I understand, but
If we short, I won't be able to get him now.
okay. Derek Meyer, no. Is that no? Hold on now. Next, somebody named Donella Cooper. Miss Cooper. Okay, Miss Cooper, this is cause number 25 CCCR 2122 case is styled the state of Texas versus Donella Cooper. Ms. Cooper, is that your full name? Okay. Ms. Cooper, would you please raise your right hand? Ms. Cooper, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Cooper, you may put your hand down. How are you doing, Ms. Cooper? I'm doing fine, thanks for asking. Ms. Cooper, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Ms. Cooper, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Cooper, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will be given information to contact him. Hold on a minute. Hey. Okay, now, Ms. Cooper. As I mentioned to you, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. Who's Mrs. Cooper, Nathan knows. Okay, now, Miss Cooper. This document states that following return of a criminal information in County Code Act Law number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand this statement?
Yes, sir.
That condition number 2, the defendant shall submit to testing for drugs and alcohol as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go to any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply. That only applies to the deed in the case. However, condition number 5 does apply. It states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. You understand that condition?
Yes, sir.
And condition number 5, the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification submitted to the court within 3 days. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond will be revoked and you'll be placed in the Jefferson County Jail. Now, you're gonna have a seat in that first chair and wait for your name to be called. All right?
I'll take this.
Yes, that's your copy. Brandon Smith. Okay, Mr. Smith, you would like to have your case reset to hire your own attorney. Is that correct? Okay. All right, your case will be reset. You can follow the bailiff and you have a next step. Here you go. Justin Kyle Cox. Mr. Cox, your full name is Justin Kyle Cox. Mr. Cox. Would you please raise your right hand? Mr. Cox, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Cox, you may put your hand down. How are you doing, Mr. Cox? You doing all right? That's good. Now, Mr. Cox, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants. While attorney recognize this document? Yes. Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? Yes. I also have another document that is titled Affidavit of Indigence. Do you recognize this document? Yes, sir. On page, look, the same document, there's a signature above the line that's titled defendant signature. Is this your signature? Yes. Now, Mr. Cox, before you sign and initial these documents, did you read the documents? Yes, sir. Did you understand what you read? Yes, sir. And is everything in these documents true and correct to the best of your knowledge? Yes, sir. Mr. Cox, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Okay, have a seat in that first chair on the wall. There you go. You looking at that plea right here? Charles Eubanks. This is cause number 25 CCCR 2110. Case is styled the state of Texas versus Charles Walter Eubanks. Mr. Eubanks, is that your full name?
Yes, sir.
Mr. Eubanks, would you please raise your right hand? Mr. Eubanks, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Eubanks, you may put your hand down. How are you doing, Mr. Eubanks?
Blessed. How about yourself?
I'm blessed as well. Thanks for asking. Mr. Eubanks, the state is represented in this case by Attorney Haley Simmons. And Ms. Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Thanks for asking. Mr. Eubanks, I have before me before we get started, you have a right to have a court reporter to type down everything that's been said. You also have a right to waive or give up your right to have a court reporter Do you waive or give up your right to have a court reporter? Okay, you have a right to have a court reporter to type down everything that's being said in this proceeding. You also have a right to waive, which means to give up your right to have a court reporter. Do you waive or give up the right to have a court reporter?
No, I don't like to receive.
Okay, so what we're gonna do, just have a seat and then we'll, Miss,
We can waive it, it's fine.
oh, you waive it?
Yeah.
Okay,
It's fine, I'll change it.
okay. Now, Mr. Let's see, what is it? Now, Mr. Eubanks, I also have before me a document on paper that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
No,
And is this your signature on the line that's titled defendant?
it is.
Are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding Trial. You recognize this document?
I do.
And is this your signature on the line that's titled defendant?
It is.
Voila. Now, Mr. Eubank, I also have a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Eubanks, it alleges that you, Charles Walter Eubanks, on or about October 31st of 2024, while you were in Jefferson County, Texas, operating a motor vehicle in a public place. This is not the right punishment for that. The box should be the Class A box. That's checked. They just checked and erased that. That's not the same punishment range. It will be the Class A punishment. Okay. Now, Mr. Eubanks, I have before me, well, let me go back to say. Now, before me, I have a document that is titled Information. In this information, it alleges that you, Charles Walter Eubanks, on or about October 31st of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Eubanks, do you understand what you've been charged with?
Your Honor.
And to this charge, Mr. Eubanks, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Okay, now, Mr. Eubanks, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there are 2 sets of initials. First set of initials is below a paragraph that's titled waiver, and it's next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document? The second set of initials is below a paragraph that is titled Discovery Admonishment, and is next to a statement that states, I do not request discovery. I choose to waive my right to discovery and enter a plea of guilty or no contest. Did you place your initials in this location?
I did.
On page 3 of this same document, there's set up was as a signature above the line that's titled defendant. Is this your signature?
It is.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
I did.
And is this your signature on the line that's titled defendant?
It is.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
I did.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
I did.
Now, Mr. Eubanks, before you sign and initial all of these documents that I just showed you, did you read the documents?
I did.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
They are.
Mr. Eubank, are you a citizen of the United States?
I am.
Say that for 6-1.
Mr. Eubank, The state is offering state's exhibit number 1 to be used as evidence in your case. State's exhibit number 1 is the first document that I showed you on this tablet. Mr. Eubank, this is the first document that I showed you on the tablet. It is also the same document that have your initials in these 2 locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
It is.
Okay. No objections. State's exhibit number 1 will be admitted. Mr. Eubank, is there any evidence that you are currently mentally incompetent to stand trial?
Getting into that.
Okay. Do you understand what's going on?
Yes, sir.
Do you have any mental illness or any mental defect that affect your ability to understand what is going on in this case?
It takes me a little time to understand it. That's in 2023, I had 17-hour brain surgery. So that's for that to be, in courts where it takes me a minute to.
But okay, it just take you a minute to understand, but once the minute is over, you do understand. Okay, so do you understand why you're here today and the paperwork that you just signed?
I do.
All right. Okay, so Mr. Eubank, the court is going to accept your plea of no contest. The court will find that you are mentally competent to stand trial. The court will also find that your plea and waivers were freely and voluntarily given. And the court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do.
And what is that agreement?
In exchange for defendant's plea, the state's offering 180 days probated over 15 months with a $750 fine to be assessed, 60 hours community service, interlock and standard DWI for his conditions of probation, Your Honor.
What's the court cost?
No, that's 377.
377.
But the court's taking consideration, I've already had the interlock.
Okay, hold on a minute. Let's see. Let me see that. You said it was 377?
Yes, sir.
Okay. Okay, now, Mr. Eubanks, the state is offering that you serve 180 days in the Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $750 plus court costs of $377 plus a DWI conviction fine fee of $100. You'll also be required to pay a probation fee of $60 a month, your announcement fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $169 a month. Will you be able to pay the $169 each month?
So, like, if I go to get set up on probation today, I pay that $750, then I'm still going to pay the $660.
Your total, see. I, ex- okay, what we do is we add up all of the fees. And then we divide it into the amount of months that you will be on probation.
Okay,
And so you don't pay it in a lump sum, you pay it in monthly installments.
am I eligible to pay it in the lump sum?
Oh, yeah, they'll take your money.
Yeah.
That's
That's what I'm looking for, what's my total?
Yeah, they'll tell you that, yeah,
They
yeah.
take your money.
Yeah. Yeah. But anyway, but if if you don't pay the lump sum, you'll be paying $169 a month.
Okay.
All right?
Yes,
All right. You'll also be required to perform 60 hours of community service. You're required to install an interlock device on any vehicle that you're on. I think you mentioned earlier that you still have it.
yes,
You just have to continue to maintain it. This is part of the probation.
okay.
You will also,
Now, does the court would take in consideration that I've done had it for a year?
no, that was a condition of your bond,
Okay,
I think, yeah. And so you'll also be required to attend and complete a DW education class, have an alcohol assessment and adhere to the other standard terms and conditions of your probation. Mr. Eubank, do you understand the state's offer?
what is?
I'm saying what I just explained to you. Do you understand?
I'm trying to.
Okay, I'll give you time.
The alcohol assessment.
I can repeat it. It's 180 days probated over the
I understand
15.
that, but I'm talking.
I think he's talking about the conditions like the interlock, the
Yeah.
DWI education,
Got that.
and then the alcohol assessment. That just, I think it may be a questionnaire or something that he has to
It's all
answer.
done with the probation.
And they'll,
Okay,
yeah,
I'm understanding.
okay. Okay, now, do you accept the state's offer?
I do.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Eubanks, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you're free to go and you have a blessed day. Yeah, you have a question? I saw you had your hand.
Thank you.
Okay, you're welcome.
Yeah, was there?
All right, same to you. Okay. Is that,
Right now.
is that the Bucky? Kendrick LaMichael Buckley? All right, how you doing? Now, Mr. Buckley, your full name is Kendrick LaMichael Buckley. Is that correct? Mr. Buckley, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Buckley, you may put your hand down. How are you doing, Mr. Buckley? I'm doing fine, thanks for asking. Mr. Buckley, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendants? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indians. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant. Is this your signature? Now, Mr. Buckley, before you sign and initial these documents that I just showed you, did you read the documents?
Yes,
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Buckley, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall.
yeah, thank you.
You're welcome. Okay. Next, Charity Drew. Okay, Ms. Drew, your full name is Charity Drew. Ms. Drew, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Drew, you may put your hand down. How you doing, Ms. Drew? You doing all right? That's good. Ms. Drew, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled defendant. Oh, is this your signature? Now, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Drew, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you. You will also be given information to contact him. The court reporter, the court coordinator will give you that information. Once she gives you that information, Ms. Drew, you'll be free to go. Please have a seat in the second chair. Have a blessed day.
It's lovely.
That's true. Casey LaRon Dooms. Mr. Dooms, your full name is Casey LaRon Dooms. Mr. Dooms, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Dooms, you may put your hand down. How are you doing, Mr. Dooms? I'm doing fine, thanks for asking. Mr. Dooms, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Mhm.
Is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes.
I have another document that's titled Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of the same document, there is a signature above the line that's titled defendant signature. Is this your signature? Mr. Dooms, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge? Okay, Mr. Dooms, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Langston Adams. Attorney Adams will be given information to contact you. And you will be given information to contact him. Our court coordinator will give you that information. Okay, once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Christopher Carter. Okay, Mr. Carter. Your full name is Christopher, is it Alandis? Alandis Carter? Mr. Carter, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, you may put your hand down. How are you doing, Mr. Carter? I'm doing fine, thanks for asking. Just, Mr. Carter, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants by Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court appointed attorney? I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes.
Now, Mr. Carter, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yeah.
Okay, now, Mr. Carter, probably need to get some information from you. Clean company systems.
Clean code.
Clean code,
Clean code.
clean code systems. Okay, let me do this here. Now, Must have stepped outside at the time. But she was one of the first ones to call. Miss. Who's Derek Myers? Did he show up? I don't think he showed up. Okay, Miss Wallet.
Yeah, he reset, he was reset, he had Burbanks.
Okay. Okay. Miss Wally. Your full name is Christy Wally, is that correct?
Yes.
Okay. Miss Wally, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing, Miss Wally?
Hi.
You doing all right?
Yes.
That's good. Now, Miss Wally, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for court appointed attorney? I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this document, there's a signature above the line that is titled Defendant. Signature, is that your signature?
Yes.
Now, Ms. Wiley, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yeah.
And is everything in these documents true and correct
Yes.
to the best of your knowledge? Now, Ms. Wiley, I read your answers. Based on your answers, you meet the eligibility requirements of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But once she gives you that information, you'll be free to go. But before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. And I'm going to go over these bond conditions with you. You have that document?
Yes.
Okay. And the document states that following return of a criminal information in County Court at Law number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol when the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And let's see, condition number 3 and 4 don't apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm ammunition unless the defendant is a peace officer as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Wiley, you're gonna have a seat in that first chair. Wait for your name to be called. Once your name is called, you'll be free to go and you have a blessed day. Okay, Carson Moore. Yeah. Okay, Ms. Moore. Um. Is your full name is Carson May Moore? Ms. Moore, would you please raise your right hand? Ms. Moore, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Moore, you may put your hand down. How are you doing, Ms. Moore? I'm doing fine, thanks for asking. Ms. Moore, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Ms. Moore, do you recognize this document?
I do.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that's titled affidavit of injuries. You recognize this document?
Yes, sir.
And is this your signature on page 2?
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
I did.
And did you understand what you read? And is everything in these documents true and correct
Yes.
to the best of your knowledge? Ms. Moore, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Christy Carthen. Attorney Carthen will be given information to contact you. And you will also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you're free to go. You have a blessed day. Please have a seat.
Yes, sir. Thank you.
You're welcome in that second chair on the wall. Christopher Carter. Okay, now, Mr. Carter, you was previously sworn in.
Yes.
And Mr. Carter, we went over the judge's explanation of rights to defendants without attorney. We acknowledge that this is your signature and your initials is on the line that state you like to apply for court-appointed attorney. Is that correct? I also have another document that is titled Affidavit of Indigence. You recognize this document? And on page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Carter, before you sign any initials, all of these documents, did you read the documents?
Yes.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. Mr. Carter, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
I would say, it's my first time ever seeing something like that. That was pretty cool.
Hmm?
Well,
Oh, okay.
my first time ever seeing
All right. Thank you.
it.
Yeah. Okay. Here you go. I think, Ms. Mosby,
We just had that one.
who was that?
That one didn't show up.
Oh, the guy that, okay, so it's the AFRS. Do we still gotta go forward with the bond, it's our AFRS.
Right, it's not part of render.
Right. It just says AFRS, okay. Next case is cause number 25 CCCR 1450, case of Styles, State of Texas versus Troy Wilson Hebert Jr. Troy Wilson Hebert Jr. or Troy Hebert was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Troy Hebert at the courthouse door. Troy Hebert did not answer. Troy Hebert has not appeared in court since the court has been in session. The time now is 12:20 p.m. on today's date of October 21st, 2025. Ms. Bailey, would you please call the name of Troy Hebert at the courthouse door?
Troy Hebert. Troy Hebert. I respond, Your Honor.
Troy Hebert was scheduled to be in court this morning at 9 a.m. The court's bailiff just called the name of Troy Hebert at 11:20, and she had 12:20, and she called his name at 9 a.m. He did not answer on either occasion. State, do you have a motion?
State moves for bond forfeiture, Judge.
Troy Hebert's bond will be forfeited and warrant shall be issued for his arrest in cause number 25 CCCR 1450. And this will conclude the calling the court's arraignment docket on today's date, October 21st, 2025, in County Court at Law number 2. And the court will be in recess till 1:30 when we will start our trial.
Thank you, Your Honor.
Okay.